Welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case, over this oral argument session, and I have on the panel with me from Marion County Judge Brian Lambert and from Seminole County Judge Eric Eisnagel. The case we have, and I don't want to butcher the name, I think it's Abarami versus Espinoza. And counsel, I'm going to assume, counsel for the appellant, that you would like 5 minutes of rebuttal unless you tell me otherwise. And just want to make sure that everybody mutes whatever noise-making devices we have, phones, anything like that may interrupt the arguments. And I guess also when you're not speaking, I guess the easiest thing to do is just put your microphone on mute. That's what I will do. And so, Attorney Pierce, you may begin.
Good morning. May it please the court. Carlton Pierce of Carlton Pierce, PA. I represent the appellant, Rula Abarumi. The appellant seeks reversal of the trial court's final judgment as it erred in the application of law and the interpretation of 3 different factors, specifically retroactive child support, alimony, and equitable distribution because of the double dip. As far as retroactive child support,
let's start with the argument that there's double counting. I was unclear from after reading your briefs and looking at the record. I'm not entirely clear on where you think the double counting of the mortgage payments is. Could you please clarify that for us? Not
a problem, Your Honor. As far as the double counting is concerned, if you look at the court's ruling as far as the denial of retroactive child support, the trial court stated that part of the reason, besides for not being pled, the other part of the reason was that he had paid the mortgage during the time period that he left.
So is it your position that's an alternative holding by the trial court?
Yes, I do believe that it was an alternative holding.
So, I mean, doesn't that put you in a tight spot between your issue 1 and issue 3, right? So either the trial court didn't consider retroactive child support, or it did, and it had an alternative holding considering retroactive child support and rejecting it. Which one is it, counsel?
Judge, that's part of the problem, is that the trial court did not clarify, because if you look at the way that it's applied, either way, it's going to end up being erroneous. And the reason why is because if she counted it then, she wouldn't be able, and when I say she, I'm talking about the trial court. If the trial court counted it the first time for its reasoning for the denial of child support, then it would not be able to also be counted in the pay down of the mortgage, because the pay down of the mortgage is at issue, and also the fact.
Well, counsel, if we view the trial court's ruling as not reaching retroactive child support, then would you agree that there's no that your argument 3 goes away? There's no double dipping, at least not yet.
I'm sorry, you're stating that if the trial court purely looked at it from a child support issue and that went away?
No. If your position is that the trial court did not reach the issue of retroactive child support, correct? That's your position on appeal.
No, I'm saying that the trial court ruled on retroactive child support and ruled erroneously on that issue. That's my client's position. Okay.
So then if the trial court reached the issue, then the whole, what is your argument? What is your first argument then? If your position is the trial court did in fact reach retroactive child support and declined to award it, right? That's essentially what you're saying?
Improperly, yes, that's correct. Otherwise, it was litigated by consent, and there's right. No because the appellee has already conceded it was litigated by consent. The trial court.
Well, it doesn't. I mean, essentially, look, they didn't appeal, right? So if the trial court reached the issue, then trial by consent seems to be sort of moot. If the trial court reached the issue, correct?
No, because the reason that the trial court used to reach the issue was that it wasn't properly pled. So the trial court misunderstood what the law was. And the law is, if you litigate something by consent, then it's to be tried and you're supposed to rule
But
on
if
it.
the trial court reached retroactive child support, then you have to demonstrate, which is what you're telling us now. Then you have to demonstrate that the trial court actually erred in its ruling on retroactive child support.
Yes.
Okay. Let's not talk about the trial by consent, because it seems like, from reading the briefs, it seems like everybody agrees it was tried by consent.
Yes.
It seems like the briefs took the position, at least at times, that the trial court didn't reach retroactive child support, didn't reach the issue. But now you're saying that the trial court did in fact reach the issue. So it seems like the only issue we should be talking about is whether the trial court erred in its ruling on retroactive child support. Correct?
No, I think you're misconstruing the brief. The brief demonstrates that what occurred in reality was the trial court's ruling on retroactive child support was that it wasn't properly pled. That in itself is reaching the issue of retroactive child support by stating that it wasn't properly pled.
It's actually not reaching the merits of retroactive child support. It's actually declining to reach the merits of retroactive child support. If the trial court said, this wasn't properly pled, therefore I'm not reaching the issue, then that's not reaching the merits of retroactive child support.
Yes, Judge, that is correct. But I think that the way that when you asked a question, when it phrased it, you did not include the stem reaching the merits of it. The question.
Well, I mean, that's okay. All right. I thought that was clear, but let's say, did the trial court reach the merits of retroactive child support? Yes or no? No.
No, the trial court did not.
Okay. If the trial court did not reach the merits of retroactive child support, then do you agree there's no double counting then? There's no double counting of the mortgage payments because the trial court didn't actually reach the merits of retroactive child support. Correct?
That would be correct. That's correct.
Okay. So if this court agrees that the trial court didn't reach the merits of retroactive child support, issue 3 kind of goes away because we're not there yet. You agree?
Part of issue 3 goes away.
What part doesn't go away?
The part where appellant was ordered to pay the entire mortgage starting December 1st, 2018 until the house sold, because that would give an unequal distribution. Anytime after a dissolution, the parties are tenants in common, and the case law and the statutory provisions specifically state that each party is required to pay 1/2. Well, in this case, the appellant was ordered to pay the full amount, and not only was she ordered to pay the full amount, he received credit for it because it was ordered to be divided 50-50. And if
was she required to pay the full amount because she had exclusive use of the home?
I do not believe that that's what it says in the final judgment.
Did she have exclusive use of the home during that time that she was paying the entire mortgage?
Yes, she did.
How is that error? Walk me through that.
It wasn't as far as the exclusive use and possession, as the court previously pointed out, that wasn't raised in itself. And also, as far as the payment of the mortgage, again, both parties were still required to pay the mortgage because even with exclusive use and possession, you're still, if you're going to gain an interest in that property, because of course you do have an interest in the property, you're still responsible for the payment unless the court specifically gives a reason why. The court did not give a reason why.
What can you cite to me? Tell me what statute or binding case says what you're saying now.
Kelly v. Kelly, the Florida Supreme Court held that tenants in common are equally responsible for the mortgage, taxes, and other responsibilities in maintaining the property. And a tenant in common who pays the full mortgage is entitled to recoup 1/2 of the mortgage from the other tenant upon the sale of the marital residence. The case law and the site for that is 583 Southern
Right.
Second.
No, I've read the case. I've also read subsequent DCA cases very clearly distinguishing Kelly versus Kelly. Can you deal with those?
I don't specifically know which cases you're referring to, Judge. I do know
they're in Westlaw. They're in the key site.
Yes, Judge. I have read some cases relating to that.
It seems like this case falls into the same sort of factual scenario as the cases that have distinguished Kelly versus Kelly. I mean, can you walk me through why that is not the case?
Well, Judge, in this case, no party, as the court pointed out, no party requested exclusive use and possession of the marital residence. And that's the key descriptive right there, is that it wasn't requested. And also there's no holding or no ruling inside the final judgment explaining why that would be the case, especially considering that the trial court stated that as far as the taxes, homeowners, and the insurance and everything else was supposed to be divided. If it's exclusive use and possession, as you're asking now, if it's exclusive use and possession whereby the party is supposed to be responsible, the party would be responsible for everything.
But why is that? Why, I mean, why is it that the trial court is required to sort of go all or nothing on that?
I'm not saying that the trial court was required, but what I'm saying is that the final judgment does not give a reasoning as to why it's having the appellant pay the entire amount of the mortgage and then not having her pay the taxes, the insurance, and the homeowner association.
Would it have been enough for the trial court to simply say, and I'm doing this because I've awarded exclusive possession of the house? Would that have been enough?
Well, depending upon the facts of the case, with the facts of this case, I think that the court should have explained its reasoning more so than what you've just stated, because there are other issues in play, specifically alimony, which was pled, and the
alimony is a different issue, right? I mean, isn't alimony a separate issue?
They're inextricably linked when you're looking at need and ability to pay and whether or not it's being offset. Whether or not, the one thing that happened as far as when the former spouse left the residence, the former spouse paid the mortgage. That was the customary of what happened between the two of them. And as I stated, one of the reasons that the court gave, the alternative reason for not awarding child support, was because he paid the mortgage. And that was in the final judgment, where that was the alternative that we discussed earlier.
Can I want to make sure I'm clear as to your issue 3. In your heading on issue 3, you're complaining the trial court gave double credit for appellee husband's mortgage payment. Yet it seems like you're arguing here today that the trial court erred because your client, the wife, was not given credit for the full mortgage payments that she made from the time of the final judgment until the property sold. Am I misreading something there?
No, there are two things there, Judge. The two things are, one, if it is considered, as far as support is concerned, the payment of the mortgage, when the trial court denied the, when the trial court denied the retroactive child support. In that case, if that were applied, then it's double dipping. But then there's still the other issue as far as the
I think what Judge Lambert is asking is, those seem like completely separate allegations of error, and shouldn't you, according to the appellate rules, shouldn't you have separated those into two different issues, issue 3 and issue 4, instead of lumping them all in under issue 3?
That would have been a cleaner way, yes.
Well, I mean, I think it probably would have been the proper way under the appellate rules, correct?
Yes, yes, I believe so. Sometimes when the issues appear to be related, some people will.
But a double dipping argument seems to me to be a completely different argument than, hey, and my client should not have had to pay the entire mortgage.
Yes, I would agree. Yes, it should have been broken out into two separate ones.
But lastly, I just want to make sure I go back to, because I'm not sure I got a clear answer. Why the cases, and there's only 2 of them, I think, but the cases distinguishing Kelly versus Kelly, why does this case not fit those cases distinguishing Kelly versus Kelly?
Since I do not have those cases before me, I would not be able to specifically identify the distinguishing factors, besides for the fact that there are no findings here to move in that direction.
Let me ask you about your alimony claim. You're saying that the trial court abused its discretion in not awarding at least a nominal or a dollar a month alimony so that the issue of permanent alimony could be preserved down the road?
Yes, Your Honor.
Well, tell me a scenario where it's not an abuse of discretion for the trial judge to do that, to not award nominal alimony in a long-term marriage.
Well, if the trial court were to go through and make the specific findings as far as why it was not appropriate and to address the issue and discuss the fact and raise it somewhere in the final judgment that it was a long-term marriage. In this case, there is no finding in there that there was a long-term marriage. And this case is very similar to Quinones v. Quinones, which is 182 Southern 3rd 702, and it's a 50 CA case where.
Counsel, I think the problem. I mean, I understand your argument, but I think the hard part for you on this argument is where in this case is there an indication that the appellee's income is going to increase in the near future, right? So you're relying on cases where a party had a high income and then right at dissolution, their income drops, maybe because they completely lost their job or they were transitioning. But there was reason to believe that their income would go up substantially in the near future because there was evidence that it was a temporary problem. Where is that evidence in this case?
Because it's in the reasoning of the trial court. The reason that the trial court denied alimony, at least according to the final judgment, was because of the debt load that the appellee had. And that debt load, if the trial court had considered the equitable distribution, that debt load would have been eliminated. And as I started to say with Quinones, it still states that even if the court somehow did not rule that the party was entitled to it, there still should have been some type of finding as far as the rebuttable presumption of alimony.
But in Quinones, that particular case, the primary income was substantially lowered because he was in transition. The party was in transition. The case specifically says it, from public service into a private law practice. It doesn't seem like we have the same exact situation here.
I didn't say there was the exact same, but I'm going with as far as the ruling of the trial court, because the ruling of the trial court, the reason that alimony was not granted was because of that debt load. And the analysis, as far as the debt was concerned, the analysis was improper. When you look at the actual analysis at the time of trial, the appellant's deficit was $1,548.
Do you have any cases that applying that rule of the nominal award of alimony to a debt load issue versus an income issue?
No. But even one of the cases cited by the appellee, which was Julia v. Julia, that was a case that appellee relied upon. It holds that it's reversible error when a trial court fails to make mandatory findings related to spousal support, even if those findings are apparent from the record. And also, Julia did not involve the sale of the house where that could have wiped out the debt. But to the court's point, no, in reference to the debt load consideration as opposed to the income consideration. But how
much difference would that make, just specific dollars, if you could tell me, on the debt load? What are we talking? I don't remember the math. How much per month?
His overall.
Now, once the debt load is gone, how much?
He owed $23,106 at the time of the trial.
Mm-hmm.
Well, I'm looking at the final judgment, and all the judge is saying is these are the guy's expenses: food, gas, vehicle, child-related, J.C. Penney credit card, et cetera, et cetera. I mean, the judge here found your party's net incomes were relatively similar. So, kind of like what Judge Eisnagel was saying, it's not a scenario where the paying spouse was earning a lot of money, then at the time of the divorce wasn't, but it's likely they're going to get it. So in a long-term marriage, you say, well, let's just reserve jurisdiction, because once stereotypically the husband was making more money, then he could pay it down the road for the long-term marriage that doesn't seem to be here. I mean, it seems to me you're saying as a matter of law in a long-term marriage, I understand the rebuttable presumption. In a long-term marriage, you got to at least award nominal alimony because sometime down the road, something might financially be beneficial so that the payee would get more money, can get more money. I don't.
No, Your Honor, I'm not. No, Your Honor, that I'm sorry if that's the way that it was interpreted. No, that's not it. This is based upon the trial court's finding as far as why it did not award any alimony, and the fact that it did not address the rebuttable presumption of alimony. Now, also, if you look at the evidence that was presented, the income beforehand, he said, oh, well, he was making a specific amount and a consistent amount of overtime. But then during the time period of the filing and subsequent to it, as a matter of fact, the closer you got to trial, came in that just went away. As far as the overtime, it just went away.
Mr.
Where
Pierce,
was the evidence?
Go ahead. I'm sorry. Go ahead, Judge Eisenagel.
Where was the evidence that overtime was likely to come back? And did the trial court make that finding?
No, the trial court did not make that finding.
Was there evidence that the overtime was likely to come back soon?
No, not specific, not as far as timing is concerned.
But does that get you over the hump then when it comes to these cases on that say that you can award nominal alimony? This isn't a situation where we have a CEO who's temporarily out of work, but likely is going to be a CEO again next month, right?
That's correct. It's not. But the issue is, again, what I focused on, and I believe that it's focused on in a brief, is the decision by the trial court. One, why the trial court said it did not award alimony, because it was established, and it says in the final judgment, that appellant had the need. And the reasoning of the trial court was that appellee did not have the ability to pay. That was solely the reason it was given. And I should point out that the evidence shows right there that he was voluntarily paying for the son's car and for the insurance and for his telephone. And the issue, of course, one of the issues before the court is whether or not the trial court complied with the rulings of Felipe and Julia, which means that there should at least be some findings on the rebuttable presumption, considering this was a long-term marriage pursuant to 61.08. At the time of the trial, they were married 20 years and 2 months, I believe.
And Mr. Pierce, we're going to have to stop there and give Ms. LeBron a chance.
Yes, sir.
So, Ms. LeBron, you may proceed.
Good morning, Your Honor. May it please the court? My name is Michelle LeBron, and I represent the appellee, Jamie Espinosa. The final judgment of the trial court should be upheld because appellant failed to meet her burden of proving appellee has the ability to pay alimony, and the court properly considered the mortgage payments appellee made as in-kind payments of support pursuant to 6130. The standard of review of the trial court.
Was it your position that the trial court did reach the merits of retroactive child support?
I believe the court did consider the merits of the retroactive child support based on the statement she makes at the end, towards the end of the final judgment, where she says that she states that the wife had not pled for retroactive child support. However, considering the fact that the husband had paid the mortgage payments for the entire duration of their separation and pursuant to the temporary order, she was inclined not to award retroactive child support for that matter.
How do we read that though, right? I mean, it's kind of just this sort of ballparking statement, right? As to retroactive child support. There's no calculation that demonstrates that there's nothing in the order that demonstrates that the trial court made the calculation and said, hey, look, they equal up. It's a wash, right? I mean, there's nothing in there like that.
That is true.
If the trial court did reach the merits of retroactive child support and essentially said, hey, look, it's already been paid because the appellants paid these mortgage payments, then is there a double counting? And if it seems like in that case, there probably would be maybe a double counting, no? Is there?
No, Your Honor, I don't believe that there's a double counting because the court did not then award the husband credit for the payments that he made. It's my understanding that it would have been a double counting based on one of the cases that I read. If the court gave him credit for the retroactive payment and then said, oh, husband, you're also entitled to receive an unequal distribution of the asset, and have wife reimburse you for those payments that you made.
In this case, the trial court ordered that the proceeds of the sale would be distributed 50-50, correct?
Yes, Your Honor.
So that's essentially your argument that, look, there wasn't a double counting at all. Even if the trial court reached the merits of child support and counted the mortgage payments there was no credit in the distribution.
That's
at 50-50.
That's my argument, Your Honor. When determining whether to award alimony pursuant to Florida Statute 61.08, the court must first determine whether the party requesting alimony has a need for support. Then the court must determine whether the other spouse has the ability to pay that support. After the court makes explicit findings of need and ability to pay, the court moves on to analyzing the factors in 6108, subsection 2A through J. The party requesting the alimony has the burden of proving the other party's ability to pay. This court held in Perino that a spouse cannot be expected to maintain the other spouse's standard of living when this maintenance stretches beyond his financial ability. The standard of living is not a super factor to be considered over other considerations of need and ability to pay. This court also held in Perino the goal of an alimony award is not to equalize the parties' incomes. In this case, the trial court made specific findings as to the party's net income in the final judgment. The appellee's net income at the time of trial was $2,936, and the appellant's net income was $2,700, a difference of just $236 per month. In analyzing the alimony factors, the court considered the extensive debt the appellee incurred during the party's separation while he attempted to pay his own expenses and the mortgage on the marital home.
Counsel, can you talk to us a little bit about, the appellant says that Kelly, the Florida Supreme Court's Kelly case applies here, but the second district in Wolf, which is a 2008 case, declined to extend Kelly and distinguished it. Which one of those cases is applicable here, Kelly or Wolf?
Your Honor, I have not read Wolf, but I would tend to think that Kelly would not be applicable because if we're referring to the time period after the final judgment, the wife is awarded exclusive use and possession. Someone had to have exclusive use and possession. She was there with the children alone since 2015, and the appellee had testified that he was living in temporary housing with his parents and needed to obtain alternative housing at the time that this case concludes. And so if the wife is in the house along with the children, she's deriving the benefit of the asset at that point. And appellee had no benefit of the asset since 2015. And so it's our position that the court rightfully asked the wife to pay the full mortgage at that time based on her exclusive use. In analyzing the alimony factors, the court considered the extensive debt the appellee incurred during the party's separation while he attempted to pay his own expenses and the mortgage on the marital home. The testimony and the evidence showed that appellee has a deficit each month. The testimony was that his monthly expenses did not yet include replacement housing for himself, as he was temporarily residing with his parents and would need to find a place to live when the case concluded. He would need a 2-bedroom apartment, which he testified would rent for approximately $1,300 per month. With the new apartment rental, he would also have increased monthly expenses for utilities as well. Neither party pleaded for an unequal distribution of assets. Therefore, the court distributed the 401k, the pension, and the marital residence equally. Taking all of those assets into consideration, appellant is in a more favorable position after the final judgment based on appellee's significant debt and the low amount of debt that the appellant had at the time. The trial court had competent substantial evidence both at the temporary relief hearing and at trial to make the determination that appellee does not have the ability to pay support by way of the testimony of appellee's supervisor as to the scarcity of overtime and of appellee's expenses. The burden was on appellant to prove appellee had sufficient income for which he can pay alimony, and she did not meet her burden. The court did not err in failing to award a nominal amount of alimony because both parties have a deficit each month.
That's not really that unusual in family law cases for everybody's affidavit to say, I'm going in the hole, because basically you have a scenario where you previously were living together with one set of combined expenses and combined income, and now you have still the same income, but an increase of the expenses. So, under that scenario, at least from my experience as a trial judge in family law, nobody'd ever get alimony, because I don't remember any husband, unless he's a multimillionaire, coming in saying, oh yeah, I got a big surplus at the end. How much does she want? So, I don't know that that's critical. I mean, I guess the scenario that's more concerning is he was making money before with overtime. Now, lo and behold, I don't get overtime now as we're getting closer to the final judgment. And now, after the fact, let's say he's starting to get overtime. Wouldn't that be a scenario where, if jurisdiction had been reserved with a nominal award of $1 a month, which your client could clearly pay, they could come back and say, see, judge, he's now making another 20 grand a year because he's got extra time as a bus driver. And that's the abuse of discretion. Isn't that the argument that's being made here?
I believe that is his argument. However, the testimony from the supervisor at the temporary relief hearing was that the overtime was scarce. My client testified, I believe, at the temporary relief hearing and at trial, the pattern in which they can request overtime, which he has to bid for it. And that overtime can only be requested on his days off. Now, with the new time sharing schedule, he's exercising time sharing with his son on his days off. So he doesn't have as many days off available to work overtime.
Yeah, but the point is, if you award the $1 a month, then 2 years from now, then if things change, if the economy changes, or he does the increase and he's now making, $55,000 or $60,000 a year as opposed to the 35 or whatever the net is right now, then you could come back. And why is that not an abuse of discretion not to at least to do that for a long-term marriage where there's a rebuttable presumption that the wife in this scenario was entitled to alimony?
Well, I think it was an error because he did not have the ability to pay at this time. And there was no
$1. You tell me you have the ability to pay $1 for the judge could say, okay, I don't think you could pay whatever the wife's asking for, but I'm going to reserve jurisdiction. I'm going to award a nominal amount of $1 a month. And that way, if things turn better for the husband down the road, if we get more people using the bus and he gets more overtime, then we can revisit it, because this is a long-term marriage.
I think that under the facts of this case, because there was no evidence that overtime was going to resume at the rate that it was before, and I believe it would have been appellant's burden to prove that the overtime would resume. In this case, I don't think it would have been proper for the court to reserve jurisdiction with a nominal amount of alimony.
So as to retroactive child support, your belief then as the judge in the second line of paragraph 30 of the final judgment, that the judge on the merits has decided that you're not there, the wife's not entitled to retroactive support because husband paid the full mortgage payment. That's your understanding, or that's your position?
Well, I don't think the judge did a full calculation, but I think that she was attempting to do equity between the parties and to not have it lost on the husband that he did make that payment for so long. So I don't think that there was a full analysis. I do recall opposing counsel submitting some child support guidelines, although the final judgment does not reflect that information, but I do recall opposing counsel submitting child support guidelines. I don't know if the court actually took the step to do the math and equal it out.
Well, that's what I was going to get to. In 2015, were there two minor children, or just, I don't recall.
In 2015, there were 2 minor children. The eldest child, I believe, aged out and graduated from high school in May of 2018, I believe.
So if the judge said, okay, this issue is tried by consent, and what I'm going to do is I'm going to consider that back in 2015, the wife was responsible for retroactive for her half of the mortgage, and the husband was responsible for his half, and I'm going to consider that to be retroactive child support, his share. Or let me rephrase that. Husband's going to pay the full amount of the mortgage. One half is what he's required to as the tenant and soon to be tenant in common. The other half we'll consider as retroactive child support. That would have been okay then, in your view?
I'm sorry, could you please restate the scenario? I didn't understand you.
Yeah, I mean, it seems like this issue, and I'm not entirely clear what the full range of the retroactive child support error is being argued by the husband, but I mean by the wife. But if the judge simply said, okay, he's paid the mortgage payment for the first 2 years of separation till filing, and therefore I guess that's the merits of you're not entitled to retroactive child support, wife. And the wife saying that's error, I believe. And your position is that's not error because that in essence was a de facto retroactive child support payment?
I believe so. It can be construed as support for the family. I mean, he was able to keep a roof over their heads during that period of time while he was at a great disadvantage. We've seen in other cases where some people walk away from the marital residence and just stop paying altogether. He did try to do the right thing and maintain the payments and keep the family in the home that they were in at the time of the separation. And so I think
as counsel, given the the context of everything, right? Your client below argued to the trial court that the issue was not tried by consent and apparently prevailed in the trial court on that argument. So given that, and then given the fact also that while the trial court did mention the mortgage payments relating to retroactive child support in the order, there clearly is no calculation. I mean, it at best was a sort of ballparking retroactive child support, right? It makes it, do you agree that it makes it difficult for this court to conclude that the trial court actually reached the merits of that issue, as opposed to just sort of mentioning it in what might have been akin to dicta, as opposed to actually considering the issue?
I think you're right.
Do you also, and just so we're clear, you now concede on appeal, you concede, I think, that the issue, retroactive child support, was indeed tried by consent, correct?
I do, after reading back through the transcript. I think when we wrote the response to the motion for rehearing, we didn't have the benefit of the transcript, but reading back through the transcript, there was great discussion and litigation over presenting evidence of their income. And I do recall that the wife was asking to be awarded the entire marital residence. And so
I guess the point is that you're not contesting that issue on appeal, correct?
I am not.
Fair enough. Okay.
The trial court's final judgment declining to award retroactive child support should be affirmed. Retroactive child support is discretionary under Florida Statute 6130-17. The petitioner filed her initial petition on February 27, 2017, and it was undisputed that appellee paid the entire mortgage from the date of the separation in November 2015 through December 2017. Beginning January 8, 2018, upon the court's oral ruling for appellee to pay half of the mortgage, appellee continued to pay $858 pursuant to the court's temporary order. Between January 28th and the date of trial in November, appellee continued to make that payment of $858 while still incurring additional debt to meet his own expenses.
Because he was ordered to.
Well,
right?
yeah, yes, Your
There
Honor.
you go. He wasn't just being a nice guy. I mean, he was ordered to do that.
Yes, Your Honor.
All right.
The court is required to consider all of the payments made to the other party or third party for the benefit of the child throughout the retroactive period. When one party pays the mortgage payment or housing expenses of another party, the court considers it an in-kind contribution for purposes of the child support guidelines to the extent that they reduce living expenses, which covers items such as food and housing. The trial court probably considered the fact that appellee had paid the entire mortgage of $1,642.09 from November 2015 to December 2017, and to do equity between the parties, the court considered this an in-kind contribution as a condition of support for the children. Subsequently, appellee continued to reduce appellant's living expenses by continuing to make that payment through the time of the final judgment, when the final judgment was actually entered. The trial court did not give appellee a credit for his mortgage payment. If the court had done so, it would have resulted in an unequal distribution of the asset. As a joint owner of the marital home, appellee was entitled to 50% of the net equity upon the sale of the home. The fact that the court gave due consideration to appellee's contribution to the reduction of appellee's living expenses does not create a credit. For example, if the court considered the payment of the mortgage as a condition of support and then ordered appellant to repay appellee for the payments he made toward the mortgage, that would constitute a double dip and would be an abuse of discretion. But here, that is not what the court did. The court merely considered all of the payments appellee made against what would have been ordered for support and determined it canceled each other out. And so for these reasons, we would ask that this court affirm the final judgment entered below. If the court is inclined to remand with any instructions regarding the retroactive child support, we would ask the court to give clear instructions regarding the credit for the payments made and how they factor into the actual child support calculation, which my reading of the case law seems to indicate that that payment that reduces the living expenses would have to be applied as income to the wife for purposes of calculating child support. And if there aren't any further questions, I will stop there.
Okay, thank you, Ms. LeBron. Mr. Pierce, there was very active questioning of you well into your rebuttal. So I'm going to give you 2 minutes to sum up your argument as your rebuttal. So you may begin.
Thank you, Your Honor. In this case, what appellee's counsel demonstrated was a clear misunderstanding of 61.3017 and as far as retroactive relief to the date of filing of the petition. As explained in the brief, 61.3017 occurs prior to the filing of the petition. That's approximately, it says up to 24 months. But also you have to look at the second period of time, which is from the point of filing the petition until the date of the trial. There's also retroactive child support there. And the case law there has specifically stated that, and that includes in the 5th District Court of Appeal in Hodge v. Hodge, it specifically states that it is reversible error not to award retroactive child support to the date of filing of the petition if there's a need and ability to pay. That need and ability to pay was previously determined by the court and it ordered child support. Now also, as far as Judge Eisnagel had brought up Wolf v. Wolf, I pulled up Wolf v. Wolf, and in Wolf, it's distinguished from this case because there was the appellant actually sought rental value for the wife who was in exclusive use and possession as far as with a domestic violence case. This case does not involve domestic violence, and more importantly, it doesn't involve.
Well, I'm not sure that's a relevant distinguishing factor. I think the Wolf was pointing out that in Kelly versus Kelly, the award of rental value was in a supplemental judgment, not in the original judgment of dissolution.
That's correct. It does say that.
And we're not dealing with a supplemental judgment here. We're sort of talking about the original judgment of dissolution, correct?
That's correct. And which brings me to the point that this is, as the court just pointed out, this is not a supplemental, this is an initial. And of course, Kelly says that you have to look at each case individually. The reason why is the rationale of the exclusive use and possession in Wolf was based upon domestic violence. This case is not. And although it was raised as far as the exclusive use and possession, as appellee promptly pointed out and correctly pointed out, below, exclusive use and possession was not pled. And as far as appellee considering, well, go ahead and apply it to child support. If it is applied to child support, as she just requested, of course, then we have to look at the unequal distribution on the back end with the sale of the house, because that money would be therefore being used for two purposes, paying the child support, and then it would also be considered paying the mortgage. And he should not be able to get double credit for both.
And counsel, thank you for your argument.
So if the judge says, okay, you needed to pay $1,642 in child support, and she paid the mortgage for the period from the filing of the divorce till prior to separation till the filing, would she be entitled to extra payment because she's paying your half of the mortgage? Would she be entitled to a credit?
If he's paying child support of $1,600, we'll just use it.
If we say, yeah, I mean, the argument seems to be, I paid the mortgage payment of $1,642 from the time of separation until the filing of the divorce petition. So the judge kind of considered that all a wash. Now, instead of paying the mortgage, if he had just been paying her $1,642 a month, and then she was paying the mortgage payment, how would that play out regarding the credits at the time of the sale of the house?
Because there are two separate factors. One, as far as the child support is concerned, pursuant to the statute, you're going to have to pay a specific amount of child support. Let's say that's $1,600. That wouldn't absolve you of the mortgage as far as if you want to pay down in the mortgage and if you want that application. Just because you're paying the wife $1,600, that does not mean that $1,600 counts for your payment of the mortgage. I haven't seen a case that makes that statement or has such a holding.
All right. Thank you, counsel, for your arguments, and we are in recess.
Thank you,
Great.
Your Honor. Thank
Thank
you.
you.